We'll have two cases on the docket this afternoon. We will take them in the order that they appear. I have an announcement for both appellants. If you wish to save time for rebuttal, let me know, but you will be ultimately responsible because you will have the clock in front of you. So, are both sides ready on the first case?
Yes, sir.
You may proceed.
I'm Mark Stope, a counsel for the appellant. I would request 4 minutes for rebuttal. May it please the court? Your Honors, this is a case about distractions and the law.
Let me ask you if you actually executed an affidavit saying that the purchase money mortgage, the senior lien, was inferior to your interest in a property that you paid $40-some thousand for, where the first mortgage was $1.7-some million. Did that happen?
I'm sorry, I didn't hear the first part of your question, Your Honor.
Did
you ask
you
about
execute
an affidavit?
an affidavit in connection with the suit to quiet title that you filed?
I don't believe there was an affidavit executed, Your Honor. I'm frankly not certain on the answer to that because I didn't think that was an issue that we were adjudicating here today, which is part of what I was trying to open with, but I don't believe there was an affidavit executed.
Okay. Go ahead.
Does this case have anything to do with a quiet title suit?
Well, the procedural posture, it was certainly a quiet title suit that was litigated, and that was litigated through the entry of final judgment, and we are now at the procedural posture of adjudicating the propriety of the lower court's order allowing J.P. Morgan Chase, which is not a party in the underlying quiet title suit, to substitute as a party more than 1 year post-judgment. I submit that that ruling was incorrect.
Okay, before you even get there, though, I think what Judge Benton is asking is as part of that quiet title suit, you basically alleged that the second mortgage, the foreclosure of the second mortgage, could extinguish the first mortgage. What legal theory supported that? I'm not aware of any.
Well, the Florida Supreme Court is currently adjudicating the issue of the statute of limitations in the mortgage foreclosure context. So that is, and the DCAs are split on the propriety of that. I don't believe there's any first DCA decisions that have recently come out on that issue, but that is one that is I've seen commonly used, and the third district and this isn't part of the briefs, but the third district agreed in Beauview, for instance, just in December of 2014, that that a mortgage cannot be foreclosed consistent with the statute of limitations when there's an acceleration and 5 years pass after the acceleration. I don't think that that's the issue that we're here on today, but I hope that that answers Your Honor's question.
Well, it has. I think that one way to look at the question, that the precise question that's before us, is whether it's in the interests of justice to allow the substitution of parties concededly after judgment was entered, and even though the transfer of interest occurred before you started your quiet title suit. But in looking at this question about the interest of justice, we are just perplexed, or I am, I won't speak for anybody else, about how you could allege that the first mortgage, the purchase money mortgage, which was a matter of record, was inferior to your interests.
I suppose I understand Your Honor's question. I can say I have done this on a handful of occasions. I did it before the 5th DCA a few months ago, and they issued a PCA in my favor when I was the appellee, and the bank in that case had appealed an order denying a 1.540 motion directed to a judgment quieting title that eliminated a first mortgage on a similar fact pattern. I've had circuit court judges rule that way on a number of...
But Judge Wolf asked you, what was your theory? Why would that recorded mortgage have been inferior to your interests?
Well, if if there is an acceleration, I feel like I'm arguing the Beauview case, which is not in the briefs, but to answer your question, if there's an acceleration and 5 years pass without a suit filed, then I believe that the statute of limitations bars foreclosure, and I believe the Florida Supreme Court will rule that way when they rule on the Bartram decision that is currently before it, reconciling the conflict between the 5th DCA's decision in Bartram and the 3rd DCA's in Beauview.
What made you think that there had been an acceleration in your case here in the Washington Mutual mortgage? I thought you,
Judge, I don't know that
you found yourself unable to even locate Washington Mutuals. How did you know there had been an acceleration?
I don't know that that's in the record before the court, and frankly, I didn't prepare for that, so I'm not sure that I remember, frankly. It may have been.
Did you know? Isn't that what you were just telling us? That was your theory?
I believe that's the case. I mean, I believe that's the case. I frankly, this issue wasn't in the briefs, and it's not part of the record, so I didn't come prepared to be talking about that. I'm trying to answer your honest questions as best I can. I mean, I believe I have many cases that have this type of issue. I have adjudicated the statute of limitations issue in this context on many occasions. That is the fact pattern that I believe gave rise to this, but frankly, again, since it was outside the record, it's not something that I was.
Well, I think what we are focused on procedurally is the substitution of parties issues, right? And so why wouldn't the interest of justice require that the senior lien holder be given an opportunity to be heard before their property interest is extinguished?
Well, I understand your question. I'm going to answer that as best I can, Your Honor. But I don't think that is the question here, because I think everything about the presentation that my opponent presented in their answer brief, and even the way that Your Honor is asking the question, is not framing the issue correctly. The issue is not should J.P. Morgan Chase be able to defend the case on the merits. The issue is, does J.P. Morgan Chase have any legitimate basis to bring a 1.540 motion asserting that the final judgment is void? Because that is the only procedural mechanism that they have in which to vacate the final judgment. And I submit that the answer to that is no. There is no colorable argument that they have presented or could present that the final judgment was void, which is their only argument when they're bringing it more than 1 year post-judgment. So the question is not, should J.P. Morgan Chase be able to litigate on the merits? The question is, should J.P. Morgan Chase be able to substitute in order to prosecute a 1.540 motion, arguing that this is void?
Do we have to reach the issue of whether the 1.540 motion is actually valid? Or are we on the issue only of giving them the opportunity to assert grounds for the 1.540 motion? Is the only order in front of us allowed Chase to intervene. It didn't say they had specific rights to do the 1.540.
Well, and given the procedural posture of the case, that's the only thing that they could do is 1.540. But I think to answer your question, I think that that's up to Your Honors. There is no case law on this issue. You know how many cases support the substitution of a party post-judgment? 0. Not one. My opponent can't cite a single case that authorizes the substitution of a party post-judgment.
Well, let me talk plain English. Something about this case stinks. I mean, Washington Mutual was a big mortgage lender. Everybody knew, and maybe you didn't, but everybody knew they went under. So where do you look to determine who took their interest? I think everybody would say, oh, I got to go to the Federal Deposit Insurance Company and find out who took their interest. The fact that you did not make that search kind of makes this case smell. Also, the fact that you are trying to get a property for $45,000 that's worth $1.79 million, or 1.79, I think it is, something along those things, also makes this case smell. So my question to you is, if I think this case kind of smells, why shouldn't I give Chase the opportunity to come up with some kind of legal theory to get rid of the smell?
Well, I understand your point, Your Honor. I think that the first answer to that question is that, to me, to the extent you think there's smell, that the smell applies equally on both sides of the table. For instance, the answer to the question, and you talk about interest of justice, we operate in a state that functions based on official records. J.P. Morgan Chase's own motion takes the position that they had this mortgage in 2008. And what did they record to show their interest in the mortgage? Nothing. Florida Statute 695.01 is fundamental. If you have an interest in property, you record it. And my affidavit of diligent search shows we looked in the Duval County official records and we found nothing recorded. And J.P. Morgan Chase wanted to take the position, for purposes of here, that they acquired all assets of Washington Mutual. That's not true. I litigate foreclosure cases, and I know that's not true, and I pointed out in my reply brief, if you look at their own motion, Exhibit 3 to my appendix, their own signature block said J.P. Morgan Chase acquired certain assets. But also, it's not just what was understood now. It's what was understood as of early 2012 when that was done. I think that the affidavit of diligent search is sufficient on its face, which under the DeMars case and the line of cases citing that makes the judgment at best voidable and not void. But there is no... My answer is there is no exception here for I don't like the fact pattern, so I'm not going to follow the law. And that's why I started out saying that Your Honor should follow the law and not just, follow your nose or they want you to be distracted by facts. The law does not authorize the subject.
And I believe you told us you do this kind of work in other situations. And so you were aware that Washington Mutual failed and was taken over by the FDIC?
I mean, as of that point in time in early 2012, I would say I believe that was the case. I think that the affidavit of diligent search indicated that that was the case. But the question becomes, from a title perspective, who are you supposed to serve or deal with?
I'm asking about the adequacy of the affidavit of diligent search and inquiry. Did you go to the FDIC website?
I think the answer to that, and I think that's outside the record for what we're doing here, but I think the answer to that is no, not initially. That is not, and frankly, this was the first quiet title suit that I had done. I've done a lot since then, but I don't think that that is necessary under the DeMars cases and the cases following it cited in the brief in order to make the judgment not voidable. It's purely a voidable judgment.
3.5 minutes. I just want to let you know.
So I would ask that I save the rest for rebuttal, if I may. Thank you, Your Honors.
May it please the Court, Matthew McGuane here on behalf of the appellee, J.P. Morgan Chase Bank National Association. The trial court did not abuse its discretion in giving my client an opportunity to raise its defenses in this case.
Okay, help me here. The fact that the case stinks is not a legal theory.
Sure.
I mean, I threw that out there, but it's not a legal theory. What is your legal theory for raising a 1.540 motion, or, that you'll have an opportunity to raise a 1.540 motion?
Legal theory, Your Honor, is that this judgment is void as a matter of law. My client, just as the Court knows, hasn't had an opportunity even to raise this argument yet. We're at this procedural stage. We're just trying to get into the court, have our day in court, and protect our interests. But to answer this precise question, the judgment is void as a matter of law. One of the cases cited in appellant's papers, Reyna versus Barnett Bank National Association, provides that a judgment is void when service of process is so defective that it amounts to no notice of the proceedings. He's taken the position that if there's a technical issue with an affidavit, it renders the judgment voidable, not void. But when the service is so defective as it is here, the judgment is void as a matter of law, and the court, on proper motion, can hear such an argument within a reasonable time if it's in fact void. In addition to other,
let me ask you, how is the appellant put on notice that your client did in fact have an interest in the property at the time the foreclosure suit was filed?
Your Honor, quite frankly, I would have started with Google. At this day and age, if you Google Washington Mutual Bank, one of the first things that pops up is largest bank failure in the United States history. The FDIC shut them down on September 25th, 2008, sold their assets to Chase, including the subject mortgage. We filed an affidavit in support of our motion to substitute party defendant where Sherman Slade, an employee of Chase, attested to the fact that Chase acquired the subject mortgage on September 25th, 2008. So in addition to just a simple internet search, which literally takes seconds. The proper
So
place.
that's like 3 years before he filed his quiet title action.
Right.
So, you want to be substituted as a party? I mean, why? I mean, he's extinguished the rights of Washington Mutual, but your problem is you never recorded anything.
The Washington Mutual mortgage was recorded. There is no case law supporting his claim that somehow he purchased the property in HOA sale in which Washington Mutual's mortgage was not named. Washington Mutual was not named in that case. Chase was not named in that case. There's literally no law out there that allows him to do what he did. Your precise question is exactly what they should have done, or, I mean, Chase doesn't need to enforce that mortgage. It's recorded in Washington Mutual's name, but Chase perfected its interest as a matter of law on September 25th, 2008, through this purchase and assumption agreement with the FDIC as receiver for Washington Mutual. Chase can enforce that mortgage without an assignment. There's no legal requirement requiring a party to record an assignment of mortgage to enforce the interest.
All right, so why don't you go ahead and file a foreclosure action?
Well, in fact, we did, Your Honor. In that case, it's not in this record, but it's been consolidated, the foreclosure action with this case. We wanted to make sure that this was cleared up before we proceeded with foreclosure. And we're entitled to foreclose without an assignment. As a holder of the note endorsed in blank, we have standing to foreclose, even if there's not an endorsement on that note.
What about his argument that the statute of limitations could extinguish your right to foreclose on the mortgage?
My understanding is that this is the first foreclosure action that's currently pending, so there wouldn't be this whole potential that the acceleration ran, the Bayview case that he referenced. By the way, that case in that argument wasn't around in 2012. I mean, these are recent decisions. So at the time, which is relevant, that he filed this and made these allegations that his client wiped this out, I mean, those weren't even legal arguments. I mean, that there wasn't case law to support
Well,
that.
obviously, there's some legal argument there because one court bought off on it.
What, excuse me?
I said, obviously, there's some argument there because one court bought off on it, right?
I think I heard something about that, Judge, but I don't know the specifics. I wasn't involved in that case. But in any event.
Yeah, but it can't be a totally spurious argument. I would hope it can't be totally spurious if one of our sister district courts of appeal bought off on it.
Sure. One thing I like to also note is that, just in terms of where we are, again, this is a substitution rule. The rule is 1.260C. The plain language of that rule permits substitution at any time. There's no limitations with.
Talking about transfers of interest that occur while the litigation is in progress.
That, I believe, I mean, what he's done here is he's citing to the intervention rule. We've substituted in under 1.260C. That rule, the plain language says, the very first phrase, in case of any transfer of interest. Any transfer of interest. Before a lawsuit was filed, after a lawsuit was filed, the clear language is any transfer of interest. So there's no sort of limitation as to when the transfer must occur based on the plain language of the rule. Further, he starts citing this 1 year requirement, his client does at least, and some sort of procedural roadblock with the substitution, which is not in the language of that rule. And there's no case law that he cited that's precluded my client from substituting in.
I think he's saying that it has to be void, or the 1 year provision in 1.540 precludes any possibility of relief, even if there's a substitution. Therefore, the interest of justice would not be served.
Well, clearly, in terms of the interest of justice analysis, I think this Court's well aware of what's happened here. The Court's repeatedly said that this stinks, and it does, these facts. If there's ever a time where interest of justice should apply, it should apply when an individual's $1.7 million mortgage is wiped out, where an entity purchases a property for $45,000, misrepresents facts to a trial court, slips one by them, gets a default final judgment without the right party in interest having an opportunity to defend its interests. I mean, these are fundamental constitutional due process concerns, having notice and an opportunity to be heard. And had he looked in the right places, the mortgage says that Washington Mutual's a organization organized under the laws of the United States of America. Why on earth is he looking in public records for the state of Florida? That's not how federal savings associations register. As Judge Wolf mentioned, look at the FDIC website, the OCC website. or just do a simple Google search. This was the largest bank failure in U.S. history, and it's hard to believe that appellant had no knowledge that that Chase didn't acquire these assets.
I have some concern, especially outside the one-year period, though, allowing people to intervene and raise new theories. You know, we have to have some concern about finality of judgments. Can you address that?
Sure, Your Honor. I would address the court's attention to the Provident Life and Accident Insurance Company case versus Pritchard. That's a 4th DCA case from 1993. We cite that on our answer brief. In that case, Your Honor, the intervener, again, we didn't intervene. We substituted as a transfer of the transfer of interest. We're not some third party with some different lien we're trying to intervene in and attack, you know, a case that's been closed. But in that Pritchard case, Provident versus Pritchard, one of the things that the court found compelling was the fact that the intervener had no notice of the lawsuit until after it occurred. And part of his decision to allow intervention post-judgment was based on that concern. In fact, the court even said it would be a harsh rule to fail to consider its intervention motion because they had no notice of the lawsuit. So to answer that question, I would ask the court to take a look at that particular case that we rely on. I think that warrants intervention
Was
here.
that under 1.260? Was
Sorry?
that case under Rule 1.260?
No, that was
That
under
the
the intervention rule.
So you're relying on 1.260 for the basis of your substitution into this process, correct?
No, I mean, I'm relying on the plain language of the rule. There's no case law that says that under this 1.260 that we cannot substitute. Couldn't be no abuse of discretion, in my opinion, based on the plain language of the rule, which provides the substitution rule, provides no limitation. There's no case law providing a limitation.
Is there any federal case law? So the comment to that rule says it's analogous to Federal Rule 25. Did you look at any of those cases to see if it's limited to transfers that occurred during the pendency of the litigation?
That wasn't raised by appellant in his papers, the analogous rule, and I haven't researched that issue prior to today. But I would be hard-pressed.
What did your research today show?
My research today, that under the plain language of the rule, 1.260, subsection C, there's no time limitation. And what really I find compelling and really bolsters the fact that there is no time limitation under the substitution rule is when you look at subsection A of that rule. Now, subsection A of that rule is substitution based upon the death of a party. That rule expressly provides that you have 90 days. You have 90 days to substitute into a case if there's a death of a party to maintain that action and avoid dismissal. 2 subsections down, subsection C, there is no express limitation as to when a party can substitute into the rule. I think if the intent, with at least respect to the state court rule on substitution, is that there is a limitation, it would have been written into the rule. But there is absolutely none. And unfortunately, there isn't any case law on this issue interpreting 1.260 subsection C, substitution for transfer of interest post-judgment.
But the comment to Rule 1.260 refers you to the analogous Federal Rule 25, and their cases there uniformly say during the pendency of the litigation.
If the Florida legislature wanted it to apply to this one, I mean, they could have.
But you didn't. I mean, this is both sides here. You didn't read the comment to the rule. Your whole case here is 1.260. You didn't read the comment to the rule.
I might have read it, but I didn't research any federal cases, which I thought was the question. But if there's an interest of justice exception, which I assume there is based on the line of questioning that started off, I would think it would apply to this case as some sort of judge-made exception to that rule. I mean, the results here are harsh. I mean, we have a entity that had a $1.7 million mortgage wiped out by a party that purchased that property for $45,000 some odd dollars without providing any notice to it, and it, quite frankly, looks like took great lengths to make sure that nobody found out about it by the way that they searched to locate the successor. I mean, in the affidavit of diligence search, appellants state that it appears that Washington Mutual might be a failed bank. Certainly, if that is the case, or they even had that suspicion, there's next steps that you take. You could look on the internet. You can look on the FDIC's website. I mean, there are ways to find out that Chase, and even if he didn't know whether it was Chase or the FDIC, because there was no assignment recorded, at the very least name both parties. I'm sure the FDIC would have stipulated that they have no interest in this loan, and Chase would have had an opportunity to defend itself. In the interest of justice, I mean, we have a significant property interest being wiped out here, and quite frankly, my client just wants an opportunity to be heard to raise its arguments at the trial level.
But you do agree the whole problem could have been avoided by recording something in the Duval County records?
I agree with that. But, were they required to? No. And can they enforce the interest? I mean, they're foreclosing now without an assignment recorded. They can do that as a holder of the note. They could do it even if there's...
If he or his LLC had sold to a bona fide purchaser, you'd be out of luck, right?
Fortunately, there's a lis pendens recorded now by Chase in connection with that foreclosure action. I don't have the exact timing on it, and I know it's not in here, but I do believe that in the record, but I do believe that it was like months after this final judgment was entered. That's when Chase learned of it and when they took steps to seek to vacate this judgment. It was, I mean, this case, this default judgment was a matter of months. I mean, the way that it was moved through the system very quickly to get it done to serve its purpose of trying to, again, reap a windfall and wipe out a $1.7 million mortgage. I have about 2 minutes left, but I don't have any additional argument unless the court has other questions. I would conclude my portion of the argument now.
Okay, thank you.
Okay, thank you, everyone.
May it please the court. Your Honor's first question to my opponent was, what's your legal argument for this being void? There was no answer to that. Their motion to vacate final judgment, which is in our appendix, shows their sole legal theory was failure to state a cause of action. That's all they asserted. The Lemaire case out of the 4th DCA in bank says that a failure to state a cause of action does not make a judgment void as a matter of law. It's only voidable, and that was a case that extinguished a first mortgage. It's precisely on point, rejecting the sole legal argument they made. So here, all of this talk about, service of process and not doing a sufficient search, all that is not only wrong, because anytime you say they should have done more to search, that makes it voidable, not void under DeMars. But in addition to that, their whole service of process argument is waived as a matter of law, because service of process has to be asserted in your first paper, and they did not put it in their initial motion to vacate final judgment. So they're not getting anywhere with their
I guess
service.
the question comes down to, can the diligent search be so negligent that it reaches the level of a void final judgment?
Well, even if you thought
Clearly
this,
the sufficiency, if it's a close question, sufficiency of the search normally couldn't be raised.
Your Honor, I think this
Void
search,
final judgment.
I think this search is facially sufficient on its face. I think it's sufficient on its face, but even if you disagreed with that, they waived service of process by not putting it in their first motion. That's black and white law, not putting it in their first paper. So they're not getting anywhere with service of process. They lose on the failure to state a cause of action. Under every 4th District judge agreed that that doesn't make it voidable. The argument about misrepresenting facts or fraud, they're outside of a year, so they don't get there anyway. So they have no argument to present, Your Honors, on how they get there on it being void. So how can it be in the interest of justice that Florida Supreme Court says it is an extremely limited exception, and I string cite all the cases that call it an abuse of discretion to allow intervention post-judgment. How can it be in the interest of justice to allow that when they don't even have a legal theory that's viable on how this judgment could be void? Not even a legal theory. I would point you to the Adhin case out of the 5th DCA cited in the briefs. In that case, the intervention post-judgment was not allowed as a matter of law when the interest was not recorded. They did not have a recorded interest. They lose. Florida statute 48.23 gives you, when there's a lis pendens recorded, you have 30 days to intervene. If you don't intervene in that 30-day period, you're out of luck.
They lose as against an innocent third party, but the suggestion that's being offered here is that there was intentional, not merely negligent, intentional misrepresentation about your knowledge about the fact that Washington Mutual had gone under and these assets belonged to somebody else, and that there was and this theory, I still don't understand how you think you can wipe out the $1.7+ million senior lien. I mean, what?
Judge, that's how, Your Honor, that's how the statute of limitations works. It's how it worked in Lemaire, which every 4th DCA judge agreed with. The first mortgage was extinguished as a matter of law. But more importantly than that, it doesn't matter that these arguments about fraud are non-starters. They're outside of a year. There's a very clear year limitation under fraud for 1.540. So they have no legal theory. It can't possibly, in the interest of justice, they have no case they can point to that's on point that authorized this.
Counselor, your time is run. Thank you very much.
Thank you, all Your Honors. Thank you.
Next case is Shearer versus Volusia County.